Newsflash, the super illegal tariffs are still super illegal. An appeals court has canceled Trump's tariffs because the president doesn't actually have the legal authority to tariff everything on the planet. But get out your bindles, because according to Trump, we're headed for the second Great Depression. And according to the Trump administration's own legal filings, Trump has essentially bet the country's entire economy on the unproven legal theory that he has the authority to unilaterally impose sweeping worldwide tariffs. And now, if the Supreme Court doesn't rule in Trump's favor, or doesn't take up the case, and allow those tariffs to continue, Trump claims that we're facing total economic collapse, the likes of which we haven't seen since 1929. Which, I'll remind you, got much worse because of tariffs. And so Trump's lawyers filed a petition for cert, demanding that the Supreme Court review the Circuit Court's decision. And on September 9th, the court accepted the case. During Trump's first term, he adjusted several tariffs, but to do this, he followed putative authority under the Trade Act of 1974. And this was after a months-long investigation into the ways that Chinese companies were supposedly harming U.S. economic interests by doing things like stealing intellectual property. And a qualified agency made an official finding that these harmful practices were in fact occurring. And then in 2018, the first Trump administration placed targeted tariffs on a specific list of Chinese products. But that was then, and this is now, and a formal government investigation with facts and a public hearing is boring and takes way too long. And we seem to be in more of a feelings don't care about your facts style of governance at this point. And on the 2024 campaign trail, Trump leaned hard into tariffs.
I said, if I run this country, if I'm going to be president of this country, I'm going to put a 100, 200, 2,000% tariff. They're not going to sell one car into the United States, because we're not going to destroy our country.
One of his favorite mantras was about tariffs.
I always say tariffs is the most beautiful word to me in the dictionary.
And basically, tariffs will cure what ails us.
Because tariffs are going to make us rich as hell. It's going to bring our country's businesses back that left us.
And after the election, he promised to, quote, on January 20th, as one of my many first executive orders, I will sign all necessary documents to charge Mexico and Canada a 25% tariff on all products coming into the United States. And in early 2025, he claimed to have emergency powers to launch a series of dramatic tariffs. First came the so-called trafficking tariffs in February, putatively justified as a response to drug trafficking and border threats. These slapped a 25% duty on nearly all goods coming from Canada and Mexico, and a 10% duty on all Chinese products. A month later, tariffs on China were doubled to 20%, while small-value Canadian and Mexican imports were let back in duty-free. Then in April, the administration escalated with, quote, reciprocal tariffs, which the administration claimed were justified because other countries were putatively treating the U.S. unfairly by charging us higher tariffs than we were charging them and engaging in supposedly other unfair trade practices. In retaliation, the administration proposed a sweeping plan to impose a 10% baseline duty on almost all U.S. trading partners, with some countries facing rates of up to 50% to offset supposed trade deficits and other supposedly unfair practices. China was singled out for especially harsh treatment. Within days, its tariff rate soared to 84%, then to a staggering 125%, before later being dialed back to 10% after a diplomatic thaw. But what followed was a roller coaster of pauses and adjustments. Economists, corporate leaders, and policy wonks declared that this kind of instability would be bad for the economy, but the administration persisted. The end result was a patchwork of global tariffs that affected nearly every U.S. trade partner and swung wildly from punitive spikes to temporary reprieves, depending on Trump's mood and what supposedly sweet private deal the country offered him, though those deals were few and far between, and really none have been actually papered. The National Emergencies Act and the International Emergency Economic Powers Act, or IEPA. The National Emergencies Act was passed in 1976 to create structure and accountability around the president's use of emergency powers, and it allows the president to unlock certain special powers when he legally declares an emergency. But it also includes several important checks on that power, like requiring the regular reporting to Congress and setting an automatic expiration date for declared emergencies. And one of these special powers the NEA unlocks is IEPA. And once a national emergency has been declared under the NEA, IEPA gives the president special powers to deal with, quote, unusual and extraordinary threats from abroad. And as we've talked about many times, its core provision authorizes the president to, quote, regulate, direct, and compel, nullify, void, prevent, or prohibit a wide range of economic activities involving foreign entities, including imports and exports. Now, IEPA has most often been used for sanctions, freezing assets, banning transactions, restricting trade with hostile nations or groups. And after September 11th, for example, President George W. Bush used IEPA to blacklist terrorist groups and their backers, making sure U.S. money and resources wouldn't aid them. But no president has ever dared to use IEPA to set sweeping tariffs. And so this was an entirely unprecedented power grab, which quickly inspired a flurry of lawsuits in courts around the country. But no president has ever dared to use IEPA to set sweeping tariffs. So this was an entirely unprecedented power grab, which quickly inspired a flurry of lawsuits lawsuits in courts around the country. And one of the biggest challenges with the lawsuits alleging abuse of existing law by political actors is that the public inevitably interprets these suits as politically motivated. And we can see that reflected in the media coverage when the Supreme Court was inevitably asked by the Trump administration to put its thumb on the scale. 73 outlets picked up the story, with about 30% coming from the left, only 10% coming from the right, and 60% coming from the center. And when you examine the headlines, you see some very interesting frames emerge. From the left, the tariffs are described as sweeping, prompting the Supreme Court to act quickly. From the right, the Supreme Court is acting urgently to decide the Trump tariffs, prompted by the lower courts ruling them illegal. And from the center, the Supreme Court is motivated to weigh in on Trump's power to impose the tariffs, implying an unanswered legal question. Now, each of these angles suggests different motivations, and the headlines you read have immense power to shape how you understand the news. And that's why I like to see the news from as many angles as I can, which I can with the help of today's sponsor, Ground News. And right now they're offering Legal Eaglets 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get the discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the sources reporting, all backed by ratings from 3 independent news monitoring organizations. And they just added a feature that covers podcasts on major stories as well. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like this related story of Trump stating that he's willing to match the tariffs the EU is proposing to levy against China and India to put pressure on Russia's oil industry. But you probably would have missed the story if you only get your news from left-leaning sources, as only 12% of the coverage came from the left, 35% from the center, and 53% coming from the right. But that's why Ground News is my favorite way to get the news. And as a Legal Eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and the blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent and balanced. So click on the link below or scan the code today, or I'll see you in court. So faced with an existential threat to their businesses, a group of companies filed suit in the Court of International Trade, the federal court that deals with this sort of subject area. And the plaintiffs argued that President Trump had exceeded his lawful authority because IEEPA doesn't authorize the president to impose tariffs at all, let alone sweeping unlimited ones like these. Plaintiffs also claim that IEEPA shouldn't have been triggered here because the statute requires a, quote, unusual or extraordinary threat, and longstanding trade deficits and supply chain issues just shouldn't cut it. And even if the law could be stretched to cover tariffs, the plaintiffs argued that would be unconstitutional because it would mean Congress handed over too much of its taxation and commerce power to the president. So under the major questions doctrine, if Congress wants to delegate these kinds of economically and politically significant powers, Congress must do that with clear, specific language, which IEEPA doesn't include. And because of the imminence of the tariffs and the existential threat to their businesses, plaintiffs asked the court to grant a temporary restraining order. Now, in response, the administration argued that the political questions doctrine bars the court from second-guessing the president's decision to declare a national emergency. But if the court did decide to hear the case, problems like trade deficits and supply chain risks count as the kind of serious threats that trigger IEEPA. And under IEEPA, once the president has declared an emergency, he has the power to control imports, which should include setting tariffs. And the administration pushed back on the plaintiff's use of the major questions doctrine because the major questions doctrine cannot be used against Republican presidents, only Democratic presidents. No, I'm just kidding. Although that is probably the case, it remains to be seen. But actually, they argued that it doesn't apply when the president is acting in areas like foreign affairs and national security. And even if it did apply, Congress already gave the president clear authority to use tariffs under IEEPA. And lastly, the government said the plaintiffs don't deserve an immediate court order stopping the tariffs because they haven't proven real harm yet, pointing out that none of them had actually paid the new duties at the time. But on May 28, 2025, a 3-judge panel of the Court of International Trade granted the plaintiffs' motion for a restraining order, finding that the tariffs exceeded the president's authority under IEEPA. The court agreed with plaintiffs that routine trade disparities and some drug trafficking issues, which are also sadly pretty routine, didn't really meet the definition of an emergency. And even if there was an emergency, the court found that the plain language of IEEPA didn't give the president authority to, quote, impose unlimited tariffs on goods from nearly every country in the world. The court then permanently enjoined the government from imposing these tariffs. The Trump administration appealed the same day and asked the Federal Circuit Court to stay the lower court's ruling. During the appeal, the Federal Circuit Court agreed to stay the Court of International Trade's ruling while it considered the case. And then it took the unusual step of deciding to hear the case en banc. En banc means that instead of a handful of judges, usually 3, the court's entire lineup of judges would hear the case, generally to make sure that a majority of the justices or judges in the Court of Appeals agrees with the verdict. Because if you only have 3 judges, you might get a wacky selection that comes up with a rule that not everyone would agree with. And this is typically reserved for cases of unusual importance and impact. And the parties reiterated their arguments, but the Trump administration upped the ante, claiming that if the court blocks the tariffs, it would basically be the end of the world. In a letter to the court, the Solicitor General, John Sauer, argued, quote, if the United States were forced to unwind these historic agreements, these are not actual agreements, but whatever. The president believes that a forced dissolution of the agreements could lead to a 1929-style result. In such a scenario, people would be forced from their homes, millions of jobs would be eliminated, hardworking Americans would lose their savings, and even Social Security and Medicare could be threatened. In short, the economic consequences would be ruinous instead of unprecedented success. Now, even if that were true, it would be a disaster of the administration's own making. The reason the administration supposedly needed these tariffs was because Trump and the Republican Congress wrote drastic sweeping tax cuts into the eponymous One Big Beautiful Bill. And even with the most generous estimate of the taxes that Americans would pay as a result of the tariffs, that would only partially make up for the shortfall created by the OBBB. But they planned to make up at least some of the shortfall with these questionably legal tariffs. But not surprisingly, the case attracted a huge number of amici, or friends of the court, to submit briefs, including senators, policy experts, scholars, and former government officials. And the Circuit Court was not swayed by the administration's proclamation of doom and gloom or their legal arguments. The Circuit Court began with a history lesson about tariffs. When the founders drafted the Constitution, they gave Congress the exclusive power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. This included the power to set tariffs. The founders vested this power in Congress explicitly because they were concerned about the president abusing his powers. When Patrick Henry worried that the president, quote, may easily become king, James Madison replied that this couldn't happen because the purse is in the hands of the representatives of the people. And for more than 100 years, tariffs were the country's main source of income. Then, in 1913, the 16th Amendment was ratified, giving Congress the power to set and collect income taxes, and the tariffs faded into the background. For most of the early history of the United States, Congress held on to its power to tax and set tariffs. Now, over time, Congress has delegated some of its authority to the executive branch, and in fact, one of the statutes that does this is the Trade Act of 1974, the statute that Trump relied on during his first term to put tariffs on China. But in the Trade Act and other statutes, Congress maintained its tariff power by setting strict limits on the president's authority in this area. These included requirements that the government conduct an investigation, give foreign powers a consultation, and take public comments before simply rolling out tariffs. And the Circuit Court pointed out that IEEPA is different from all of the statutes that delegated tariff power because IEEPA has none of those requirements. This raised red flags for the court because it makes it look like IEEPA is either not a delegation of tariff power at all, or is an unconstitutionally vague or broad one. Additionally, under the court-created major questions doctrine, which has recently been a favorite of conservative justices who want to curtail agency power, if Congress intends to delegate issues of, quote, vast economic and political significance to the executive branch, that delegation must be very explicit and give, quote, clear congressional authorization. And the Circuit Court concluded that IEEPA simply doesn't meet that standard. IEEPA states that once the president declares an emergency under the NEA, he may, quote, investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of any property in which any foreign country or national thereof has any interest by any person. The parties in the courts all zeroed in on one part of that admittedly convoluted phrase, that the president has the power to, quote, regulate importation. The Trump administration claimed that meant the president has the power to enact tariffs, even sweeping ones, without any additional congressional authorization or oversight. The plaintiffs argued there was no such power in the actual text of the statute, and the Circuit Court agreed with the plaintiffs. And as the Circuit Court pointed out, IEEPA never uses the word tariff or any synonyms like duty or tax. And Congress is clearly capable of using such clear terminology because it has in numerous other statutes. And a common understanding of the word regulate simply doesn't sweep in vast, seemingly boundless tariff power against basically every country in the world. Many agencies regulate, none unilaterally impose worldwide tariffs. And the Circuit Court pointed out that even the founders understood regulation and tariffs to be different things, because they're discussed in different sections of the Constitution. As the court held, quote, whenever Congress intends to delegate to the president the authority to impose tariffs, it does so explicitly either by using unequivocal terms like tariff and duty, or via an overall structure which makes clear that Congress is referring to tariffs. The Circuit Court found that the best argument the Trump administration had managed to muster was based on a case called Yoshida International versus United States, a 50-year-old decision by the Circuit Court's predecessor, the Court of Customs and Patent Appeals, though that decision was not binding on the Circuit Court. Though it was a really interesting case. In 1971, facing a balance of payment crisis, President Nixon temporarily set aside the tariff agreements that had lowered statutory rates. This effectively resulted in a 10% temporary increase in some import duties. But this temporary duty was specifically set to not exceed the amounts set in the congressionally approved tariff schedules. And to do this, President Nixon did not use IEEPA, but the predecessor statute, the Trading with the Enemies Act, or TWEA, though it did include similar regulate importation language as in IEEPA. But the Court of Customs and Patent Appeals reversed the lower court's decision and ruled in favor of President Nixon. The court reasoned that the Trading with the Enemies Act broad emergency powers, including the authority to regulate importation, did encompass the limited power to impose a surcharge, provided it was appropriately and reasonably related to the declared emergency, it was temporary, and did not override Congress's tariff scheme. So while the Trading with the Enemies Act did have similar regulate importation language as IEEPA, the circuit court here easily distinguished Yoshida from the current case. First, in Yoshida 2, President Nixon's temporary duty increase was explicitly set to not exceed the tariffs already approved by Congress. Trump's 2025 tariffs, on the other hand, vastly increased tariffs far beyond congressionally approved schedules and directly contradict a whole raft of free trade agreements. Also, the tariffs in Yoshida 2 were time limited. Trump has set no time limit on the 2025 tariffs. And as the circuit court here noted, quote, Yoshida does not broadly conclude that regulate importation must be read to include any type of tariff imposition. In fact, it held the opposite. The Yoshida court expressly said that, quote, the executive does not here seek nor would it receive judicial approval of a wholesale delegation of legislative power. So in a way, the Trump administration was trying to claim that Yoshida stood for the exact opposite of what the case actually stood for. But I guess that's what you have to do when you have no actual legal arguments, or as the circuit court said, quote, a wafer-thin reed on which to rest such sweeping power. So the circuit court ruled against the Trump administration on the merits. The judges punted on the question of whether or not the lower court could impose an injunction. They asked the lower court to consider the recent shadow docket case Trump versus Casa, which appeared to eliminate the possibility of nationwide injunctions. Yes, the injunction in the lower court here came out before the Supreme Court sort of did away with nationwide injunctions. Now, it's still possible that all the tariffs will be enjoined, but it might need to be on a class-wide basis, meaning that the plaintiffs and the lower court will need to jump through some extra hoops to get the tariffs actually enjoined. Additionally, the opinion was not quite as broad as it could have been, possibly to avoid having the Supreme Court take up the case. The court stated, quote, we're not addressing whether the president's actions should have been taken as a matter of policy, nor are we deciding whether IEEPA authorizes any tariffs at all. Rather, the only issue we resolve on appeal is whether the trafficking tariffs and reciprocal tariffs imposed by the challenged executive orders are authorized under IEEPA. We conclude that they are not. And while the court says that they're not deciding whether IEEPA authorizes any tariffs at all, it's kind of hard to read this opinion any other way. So it'll be very interesting to see what the Supreme Court does here. The court could just simply not take the case up and let the opinion stand, or a particularly politically motivated Supreme Court might say, nope, Trump gets to do whatever he wants with tariffs. But at the moment, the Trump administration went absolutely apoplectic. They begged the circuit court to stay its ruling so they could appeal to the Supreme Court. Commerce Secretary Lutnick claimed that the ruling would, quote, cause massive irreparable harm to the United States and its foreign policy and national security, both now and in the future. Treasury Secretary Bessent argued that it would lead to, quote, dangerous diplomatic embarrassment, and Secretary of State Rubio claimed this would even hurt the Ukraine war negotiations. President Trump took to Truth Social to post a characteristically restrained response, proclaiming that, quote, if allowed to stand, this decision would literally destroy the United States of America. And as promised, the administration appealed to the Supreme Court. And according to President Trump and his lawyers, quote, 1 year ago, the United States was a dead country, and now, because of the trillions of dollars being paid by countries that have so badly abused us, America is a strong, financially viable, and respected country again. Now, I'll leave you to consider whether you think the United States is more respected than it was a year ago, but the Supreme Court has agreed to review the case on an expedited basis, and briefs are due in a couple of weeks, which is lightning fast for the Supreme Court, which is galling in its own right because the Supreme Court, when it wants to, can move really fast. And when it doesn't want to, as in the case of the president's immunity case, which took basically 2 years, well, they'll just go with the regular course. But tariffs are important enough to take them on an expedited basis. So the ball is in your court again, Chief Justice Roberts. But if the Supreme Court does affirm the circuit court's decision and invalidates the tariffs, well, then you're probably going to want a good lawyer to get your refund from the tariffs back. Luckily, I know a guy. Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team. So a bunch of Redditors on Wall Street Bets found out that a hedge fund was shorting GameStop, so they thought it'd be fun to raise the price. In the process, they may have destroyed the financial markets as we know them. Then the hedge fund says that the Redditors are manipulating the market. The Redditors say that the hedge fund is manipulating the market. And then Robinhood says that no one can even trade and everyone loses a ton of money and everyone's gonna end up suing each other. But Hans, Booby, I'm your white knight.
I must have missed 60 minutes.
And I'm here to explain what in the world is going on with GameStop, Reddit, Robinhood, and the entire stock market, and whether any of this is legal. Sponsored by Ting Mobile. Hey Legal Eagles, it's time to think like a securities lawyer because trading on the stock market is booming right now. According to online brokerages, there's been a huge increase in trading activity during the pandemic, and in particular, a ton of people have been hanging out on the subreddit forum Wall Street Bets, where they discuss stock tips, information, while also making fun stock memes. Basically, stonks. And part and parcel to that, many people have signed up with the trading app and brokerage known as Robinhood, which says it's on, quote, a mission to democratize finance for all. Now, Robinhood is particularly interesting because unlike most brokerages, they encourage or at least allow a huge number of people to trade on margin or to access options trading, which, as we'll talk about in a few minutes, is sort of like giving dynamite to children. Now, of course, that might cause a huge amount of damage, but it's definitely going to be fun to watch. And speaking of which, there are a lot of gamers on Reddit, and they've taken an active interest in a retail video game shop known as GameStop. There are still 5,000 GameStop stores around America, but there's also some reason to think that GameStop is going to struggle in the near future. It faces challenges like closing malls and competition from illegal downloads, and also legal downloads, since a lot of people are downloading games instead of purchasing the physical copies in brick and mortar stores. The company doesn't expect to turn a profit until 2023. Some people think GameStop may even disappear just like Blockbuster. But not everyone agrees that GameStop is on their last legs, and the people of Reddit have been talking about GameStop as a good company for a couple of years. Then some big-time investors announced that they had invested in GameStop, including the co-founder of the online pet store, Chewy. This made some investors take notice, and Redditors realized that many investors had taken a short position on GameStop. The people of this subreddit decided that if they acted in concert to drive up the price of the stock, they could actually make a good profit by squeezing people who had shorted the GameStop stock. Man, try saying that a couple times fast. But just a few days ago, there were 1.9 million members of Wall Street Bets. Now it's up to 4, maybe 5 million members of Wall Street Bets. So if a substantial percentage of those people bought GameStop, then they really could have an impact on the stock. And that is exactly what we saw happen. In January, Redditors got to work buying up GameStop stock. GameStop's stock price was trading at under $20 at the beginning of the year, but by January 27th, it had soared to $350. Now the financial industry is up in arms. The SEC is watching. Redditors are pushing up the price of several other stocks, including AMC. Elon Musk and the Winklevi twins are cheering them on. And so there is a bit of a David and Goliath framing in this whole war, especially if you're reading Reddit. The Redditor investors are saying that they're doing just what regular folks do when they invest in the markets, trying to bet on stock prices on the rise. So although the traditional investor community is somewhat aghast at all this activity, one could argue that the little guys and gals are just trying to do what the wealthier people have been doing for years, hoping to make money from a company's growth. Though the giant hedge funds, many of whom drive the short stock positions, are pretty mad about this. And they are, of course, the enemy of the people, or at least that's according to Reddit. But before we grandstand too much further down the Victor Hugo track, keep in mind that there are lots of institutional investors like these hedge funds, like pension funds, endowments, and credit unions, who may suffer also huge losses because of what these Redditors are doing with GameStop and the reverberations that are going through the entire stock market. Which takes us to the crux of what's going on here, because you can't understand the GameStop controversy without understanding the mechanics of the trades that are going on. The question is, who is getting hurt by traders trying to inflate the stock price? Well, it's the people who took a short position on GameStop. And here's a quick explanation of what that means to short a stock. People obviously invest in the stock market to make money, and most small investors try to buy a stock that has not yet reached its full potential, making the bet that something will happen to increase the value of that stock or security.
Stonks.
But investors can also bet against a company's future potential. This is called shorting a stock. Shorting a stock enables an investor to actually make money when the stock goes down, because you can't make money by buying a stock hoping it goes down, because then the value of the thing that you have purchased has gone down. For an investor to short a stock, they actually have to borrow the stock from someone else. The investor does this by opening a margin account, which lets them borrow the stock itself. The short seller wants to see that the stock's price will fall in the future, allowing the short seller to buy the stock back at an even lower price and pocketing the difference. But this is a riskier position than simply buying a stock with the hope that the value goes up. When you buy a stock at, let's say, $20, the most you can lose is the amount you paid, $20. And that will only happen if the stock you bought goes to zero. But shorting a stock is dangerous because at some point you must buy back the stock that you borrowed. So if you're shorting the stock, you borrow the stock at, let's say, $20 and it skyrockets to $500, you're in a world of hurt. If the value of the stock goes up, there's no limit to how much you might lose. The downside risk is literally infinite. You might have to buy it back at a huge loss. In our example, the short seller is squeezed. They need to pony up $500 on an initial investment of only $20. So you can do the math.
I'm in danger!
So this appears to be what happened with the Reddit day traders versus the institutional investors who took a short position on GameStop. A lot of the people on Reddit just simply like GameStop as a company, so they wanted to build up the price. And if they could destroy a hedge fund at the same time, so much the better. And at some point, Redditors on Wall Street Bets realized that more people were shorting the stock than actually owned it. In fact, 140% of the float. A lot of people think that this is illegal. It's not. This is a relatively normal thing. And hedge fund Melvin Capital was one of the hedge funds who was on the other end of the trade. We know by now that Melvin Capital has closed out its short position, which means that they had to buy all the stock that they were shorting at a much, much higher price. No one's been able to exactly confirm how much they lost, but we do know that Citadel and Point72, bigger hedge funds, have infused close to $3 billion to Melvin Capital to shore up its finances. And Melvin Capital only had roughly $12 billion to start. And this has fueled speculation that Melvin Capital might have gone bankrupt if not for the cash infusion. But that's where things got even crazier, with the price of the GameStop stock fluctuating wildly, going up thousands of %. In the middle of all of this, Robinhood, the preferred brokerage and trading app of the people on Wall Street Bets, decided to stop all trading on GameStop on January 28th. And some have reported that as many as half of the people that use the Robinhood app in general had some sort of position on GameStop. And some have reported that after Robinhood stopped all trading on GameStop, they allowed some people to exit their positions but not buy back in. And also some report that Robinhood was actually closing their positions and selling other options or stock in either GameStop or AMC, causing fury among the people that were trying to hold on to the stock forever. So with that admittedly superficial explanation of the facts here, now we get to the legal questions. Is any of this illegal? Is it illegal for a bunch of people on the internet, if not to band together, then at least express what they're going to do in the hopes that they drive prices in a certain direction? Does the SEC care about that? Is it illegal for Robinhood to prevent people from trading in the way that they want? Is that something that can give rise to a class action lawsuit? And of course, the initial action that gave rise to all of this, is it legal for the hedge funds to have a massive short position and try and drive the market? And the answer, as with most things, is it depends. So let's first talk about market manipulation. As you probably know, securities fraud is illegal. Some common types of security fraud include manipulating stock prices, lying on SEC filings, and committing accounting fraud. But fraud also includes activity that manipulates the market. So what do we mean by market manipulation, and why does it matter? Market manipulation tends to distort the prices of stocks and securities, which damages the market's integrity because the conduct can lead to other market participants to believe that the market is rigged or unfair. And of course, it actually changes the prices that people pay for these things.
Because our economy is rigged.
And after the financial meltdown of 2007-2008, that belief was obviously somewhat justified, and many people lost their homes and life savings, while giant financial institutions got bailed out after going effectively bankrupt. Now, after the financial crisis, Congress passed the Commodity Exchange Act as a method of combating fraud in financial markets. Congress added the CEA Section 6C, which prohibits manipulative and deceptive devices and contrivances, and adopted a rule which prohibits any manipulative device, scheme, or artifice to defraud. Now, market manipulation has been illegal for a very long time. I believe it was in place in the original Securities and Exchange Act of 1934 under Rule 9. But I'm going to focus on the CEA definition of market manipulation because it's both more recent and seems to have a reasonably clear test. Now, whether there is market manipulation under the CEA is decided by a four-part test. That the accused had the ability to influence market prices. 2, that the accused specifically intended to create or affect a price or price trend that does not reflect legitimate forces of supply and demand. 3, that the artificial prices exist. And 4, that the accused caused the artificial prices. So the first question, did Redditors have the ability to influence market prices? Well, it seems clear after a few days of this that the answer is obviously yes. They succeeded in dramatically raising the price of stock. Now, did they intend to inflate the GameStop stock in a way that was illegitimate and did not reflect the forces of supply and demand? Well, obviously you can argue it both ways. Now, on the one hand, this might be an example of classic market manipulation known as a pump and dump scheme, but it doesn't really fit exactly in that milieu. In a classic pump and dump scheme, fraudsters talk up stocks claiming that they have inside information about something that will cause a stock's value to skyrocket. This inside information is actually just nonsense, and the goal is to entice buyers to quickly buy up penny stocks, and after the buyers jump in, the fraudsters sell their own shares, making a big profit, but causing the price to drop dramatically. Of course, the new buyers are left holding their hat and lose their money. This used to happen through cold calls, but in the modern era, chat rooms and forums have been fertile grounds for fraudsters illegally giving false information in the hope of driving up a stock price so that they can sell for much less. Pump and dump schemes are clearly illegal under several laws, such as the Securities Act of 1933, the Securities and Exchange Act of 1934, and 18 U.S.C. Section 371 at SEC. Now, if this activity does fall under the rubric of market manipulation, it would qualify as what scholars call open market manipulation, because this isn't happening behind closed doors. This isn't happening because of a cold call. It's happening in plain sight. It's happening on the internet, and everyone effectively has access to this information. And the SEC argues that market manipulation can in fact happen through social media. Quote, one way fraudsters may exploit social media is to engage in market manipulation, such as spreading false and misleading information about a company to affect that stock's share price. Wrongdoers may perpetrate stock rumors on social media as well as on online bulletin boards and internet chat rooms. The false or misleading rumors may be positive or negative. And the subreddit Wall Street Bets really seem to be exploiting social media to spur interest in lifting the GameStop stock price in order to manipulate the market. 4 months ago, a post appeared on Wall Street Bets with the subject "Bankrupting Institutional Investors for Dummies," featuring GameStop. There's been a perception that the traders of Reddit are just internet trolls out for a joyride, and the title of the post certainly reinforces that perception. You could also interpret this post as evidence that the Redditors wanted to manipulate the market for GameStop stock in an illegal way to hurt big investors who shorted the stock. On the other hand, there's not much evidence that the posters who used Wall Street Bets were lying about GameStop or creating false rumors designed to pump up the stock's value so that they could induce people to buy the stock. Wall Street Bets also has a counter-argument that there's evidence that Redditors were being thoughtful about their position, not intending to screw people over. The post isn't just about bankrupting short sellers. It lays out many reasons to believe that GameStop will make it as a going concern. Quote, "Well, it turns out their books are rock solid. They offered their creditors a new set of terms to push back debt for 2 years. 50% of them took it. They have eliminated all excess goodwill impairments. They're in a $300 million net cash position with significantly reduced inventory, which explains the sharp reductions in Q1 sales, and massively cut SG&A by 28% in preparation for the console cycle." And of course, many things can be true at once, especially when you're dealing with a group of potentially thousands of people who all have different motivations for what they're doing. Some traders shared apparently legitimate information about GameStop and talked about it. Their arguments appeared to be convincing to lots of other traders. They have a free speech right to make these statements. So was that market manipulation? Well, we have to talk about intent, because the SEC and other enforcement agencies argue that even legitimate transactions are manipulative if the trader intends to manipulate the market. The government's position is that an investor's intent is enough to turn a legitimate transaction into illegal market manipulation. And anyone who's watched this channel before at all knows that the same actual conduct can become illegal based on the mens rea, the mental state that you have when you conduct that action. And of course, the traders of Reddit seem to have a mixed motive, and there are lots of different people acting for many different reasons. On the other hand, there's almost no argument that this isn't a really weird and interesting case, in part because you generally don't have the telltale signs of securities fraud. This is not the classic case where someone is talking up a stock, getting other people to buy so that they can sell at a higher price themselves. Really, while there are exceptions to this, it seems that most of the things that people are talking about on Reddit are true. They are not false. They are talking about real things in the world as well as what they intend to do. They're trying to get the entire internet to buy the stock, hold it, drive up the price, screw over the hedge funds who are shorting it, and potentially save a company that a lot of people have fond memories over. Though, granted, fraud is not required for market manipulation under the SEC's definition. So just because people have good motives doesn't mean that their intent doesn't qualify as illegal market manipulation. And at the same time, anytime you have a whole bunch of people coordinating to change the price of something, you have to ask the question, is that an antitrust violation? Because the Sherman Antitrust Act, Section 1, deals with setting market prices, and that applies to even individuals. It doesn't just require that monopolies and cartels are the ones that can't set market prices. When you engage in a conspiracy to set a price, you might be engaged in something illegal under the Sherman Antitrust Act. But let's talk about who's manipulating whom here, because one reason there's so much fury over this situation is that people feel like markets are nothing but a fake game anyway. And there's certainly a kernel of truth to this, since everyone that participates in the market changes prices by their very participation in the market itself. And that changes the prices of stocks and securities to some small degree. But of course, the market is regulated, and in other words, there are laws that constrain traders from crossing certain lines. And the Reddit investors claim that the hedge funds get to do whatever they want to manipulate the markets, crossing every line that retail investors don't get to cross and are getting punished because of trying to use the same tools that the hedge funds have been using for years. And a lot of people would absolutely argue that this is a question of under-enforcement of the SEC's rules rather than over-enforcement, that there's nothing that would exempt the hedge funds from the exact same rules as everybody else. It's just a question of the SEC's resources. The SEC has been classically underfunded, and there's no doubt that the actual definition as codified in the law of market manipulation is incredibly broad. It's another question entirely whether all of the activity that falls under that definition should be considered illegal or not, but there's nothing that would exempt the hedge funds from being punished under those same rules if the SEC decided to make that a priority. But that being said, there is no validity to the idea that short selling alone is an illegal practice, even if someone you don't like is doing it. Short selling has existed for hundreds of years, basically as long as there has been stock markets. Short squeezes have existed, gamma traps have existed. All of these are just tools and in and of themselves don't qualify as market manipulation. But that being said, since we're talking about the hedge funds, let's talk about the allegations of collusion between Robinhood and the hedge funds themselves. Many have speculated, some with more evidence than others, that Robinhood agreed to stop trading on the GameStop stock, specifically as a concession to hedge funds that it does business with in one way or another. And these allegations seem like more conspiracy theories than they are based in real life. That being said, it is also possible, if not more probable, that these actions are related to legitimate business concerns rather than a conspiracy to defraud Robinhood customers. For example, most people are trading on margin, which means that they're not actually purchasing individual stocks so much as getting the right to purchase the stocks from Robinhood and the market makers that Robinhood interacts with. And because of that, a lot of these transactions don't clear for many days after they're put in place. These are incredibly complicated transactions that involve a number of different companies. And in this instance, Robinhood, number one, was probably worried about its own liquidity given the incredible volatility going on to be able to fulfill these orders. Number two, it was probably worried about the counterparty risk of the companies that it was dealing with to make the markets and fulfill these orders. And number three, it was probably worried about the actual ability of its customers who are trading on extreme margins to place these orders to actually fulfill the things that they were putting in place. So it's entirely possible that Robinhood had legitimate business justifications for limiting the trading in the way that it did. Though just because Robinhood might have had some legitimate business reasons for undertaking these practices, you can absolutely understand why users of Robinhood were furious that Robinhood prevented them from buying more shares of GameStop while only allowing people to sell their positions in GameStop, which apparently resulted in the price of GameStop plummeting. And at the same time, there were even isolated reports of individual users who said that Robinhood literally sold the stock that they had purchased in GameStop. Though I have to believe that in those particular cases, those users were trading on margin and were probably facing a margin call where in order to meet the reserve requirements for their margin account, the brokerage sells stock to meet that reserve requirement. That's fairly common when people are trading on margin, and I'd be surprised if Robinhood sold people's positions who weren't subject to a margin call. But the bottom line is that users of Robinhood are absolutely furious, often for a perfectly legitimate reason. And so, because this is America, they did what Americans do, and they almost immediately sued Robinhood. The first lawsuit filed by Robinhood user Brendan Nelson in the Southern District of New York, the SDNY, alleges that Robinhood engaged in unlawful market manipulation by removing GameStop stock from its platform. And Nelson seeks to make his suit a class action. And there's another lawsuit filed in the Northern District of Illinois by Robinhood user Richard Joseph Gatz, and says that Robinhood protected institutional investments at the expense of its retail customers, the traders, the Wall Street bets traders. Gatz alleges that this sudden halt resulted in major losses because prices were decreasing and Gatz couldn't make any moves. So Gatz is representing himself, and it seemed like immediately after Robinhood started doing this, people started clamoring for a class action lawsuit. And many people asked, can Robinhood be allowed to screw over its user base in this way? Well, I hate to be the bearer of bad news, but it's very likely that these lawsuits are going to be dead on arrival for a couple of different reasons. Number one, when you sign up for a Robinhood account, you are forced to sign up for their terms and conditions. To trade on Robinhood, you have to sign their customer agreement. Regardless of whether you don't read it, this is generally an enforceable contract. So the first question is, what did all of the users agree to? And one of the very first things that you'll see, which is very, very bad news for someone trying to file a class action lawsuit, is that everyone under Section 38 of the user agreement agreed to arbitration and agreed to forego a class action suit. Arbitration, as you probably know, is a form of alternative dispute resolution for resolving disputes out of court. Now, arbitration is often seen as a boogeyman within legal circles. People think that arbitration just means a plaintiff will never get anything. And that's simply not true. It just means that things will be adjudicated in front of an arbitrator instead of a court. But an arbitrator has the ability to fashion almost any remedy. So theoretically, you can get exactly the same remedy that you can get in a courtroom in an arbitration. They have the power to do so. And the big issue here is that the arbitration clause includes a class action waiver, which means that you're not going to be able to have a class action represent all of the users of Robinhood, even if you were able to meet all of the requirements for a class action under Rule 23, which I am very, very skeptical that a plaintiff's lawyer would be able to meet the requirements that you need to have a class action in the first place. Though at the same time, that can be both a sword and a shield. We've seen many times where a company has included a class action waiver, thinking that by breaking up every individual plaintiff into their own arbitration case, that's actually in their favor, except that when thousands of individuals take them up on that and have the company pay for the arbitration that's going on, the company can get really screwed because they'll end up paying a huge amount of money just to go forward in arbitration. So sometimes arbitrations are good, sometimes they're bad. They're just a tool. But in this particular case, it's going to result almost certainly in the dismissal of the class action suit that was filed against Robinhood. But then we get to the even more fundamental issue here, which is what the user agreement allows Robinhood to do. Even if plaintiffs could get around the arbitration clause, their arguments would probably be doomed by the other provisions of the contract that all of the users signed. For example, the agreement allows Robinhood to take into account market volatility. Section 13, market volatility, market orders, limited orders, and queued orders. I understand that during periods of high volume, illiquidity, fast movement, or volatility in the marketplace, the execution price received may differ from the quote provided on entry of an order. I may receive partial executions of an order at different prices. Of course, Robinhood reserves the right to restrict trading or prohibit it altogether. Section 16, restrictions on trading. I understand that Robinhood may in its discretion prohibit or restrict the trading of securities or the substitution of securities in any of my accounts. I understand that Robinhood may at any time at its sole discretion and without prior notice to me, 1, prohibit or restrict my access to use the app or the website or related services and my ability to trade. 2, refuse to accept any of my transactions. 3, refuse to execute any of my transactions. Or 4, terminate my account. Now, that says nothing about whether this was a good business decision or not. People are rightfully upset. People are furious with the decisions that Robinhood has made, regardless of whether Robinhood had to do it, whether it's colluding with the hedge funds or not. People are probably going to leave Robinhood en masse because they hate the way that they have been treated. This is only to say that the user agreement that Robinhood wrote and made all of its customers signed appears to give them a lot of leeway, and I would not be surprised if these lawsuits fail simply because the customers agreed to it in advance. But if you don't like it, you can do business with somebody else, and maybe that's a good idea. As Matt Levine, who is absolutely the best financial writer writing today, put it. Also, I have to say that if Robinhood stops letting people gamble on meme stocks, that is going to hurt its ability to attract customers who want to gamble on meme stocks. I simply couldn't have said it better myself. Just because it's legal doesn't mean you have to like it. But if you want to gamble on meme stocks, you're gonna need a cell phone to mess with the app. And the best cell provider is Ting Mobile. I personally switched to Ting Mobile. Why? Because of this. Yes, this is an actual bill that I actually got, and I switched. And it's great because Ting Mobile has 3 brand new plans to make sure that that never happens to you. You can get talk and text for just $10 a month and pay for the data you use, get 5 gigabytes for $25 a month, and even unlimited for just $45 per month. And switching plans is actually really easy because you can keep your same phone number and use pretty much any phone. And the service is great too because Ting partners with several massive networks, very possibly the exact same network that you're using right now, but at a huge discount. Now, contractually, I can't tell you which ones they partner with because I always respect contracts, but I'll give you a hint. My service hasn't changed at all. Now, I've been on the phone with my last provider for hours on just the simplest things, but you can transfer service to Ting by ordering a Ting SIM card, popping it in, and setting it up. No phone call to your old legacy carrier at all required. It's like magic. And if you're around Wi-Fi all the time, like you're working from home, Ting still gives you their Flex plan, which gives you the option to just pay for what you use. It is a smarter, cheaper version of the same plan that they've always had. Now they're just adding unlimited versions as well. So if you want unlimited data, go crazy. If you go to legaleagle.ting.com or click on the link in the description, you can use your last bill to compare just how much you would save. And Legal Eagles will get a $25 service credit that could cover months of service. So just click on the link in the description to give it a try. Plus, clicking on that link really helps out this channel. So, do you agree with my analysis? Leave your objections in the comments, and check out this playlist over here with all of my other real law reviews where I talk about all the crazy stuff that's happening in the legal world today. So click on this playlist, and I'll see you in court. In these trying times, when our nation is so divided, the only thing that can bring us all together is kicking one of the two presidential candidates off the ballot. Yes, that'll do it. Now our nation can heal.
God bless America.
Yes, a few months ago I told you that there was a possibility that Donald Trump would be ruled ineligible for the presidency because of Section 3 of the 14th Amendment. And now one state has actually booted him from the ballot. On December 19th, 3 years to the day after Donald Trump sent this infamous tweet announcing a mass protest, "Be there, it will be wild," the Colorado Supreme Court held that Trump is disqualified from holding the office of president because he participated in an insurrection. As a result, the court ruled that Trump cannot be listed on the Republican presidential primary ballot in Colorado. This decision opens up a big can of worms for the embattled U.S. Supreme Court. Will it overrule the Colorado Supreme Court? How will it structure its decision? What precedent might this set for other states? And of course, what's also going on with Michigan and Maine as Trump gets kicked off another ballot? Today, we're going to talk about the ramifications of this decision. But first, what in the world just happened in Colorado? Well, in October, a group of Colorado electors eligible to vote in the Republican presidential primary, including both registered Republican and unaffiliated voters, filed a petition in the district court for the county of Denver, asking the court to rule that the former President Trump may not appear on the Colorado Republican presidential primary ballot. The plaintiffs asserted that he, quote, wasn't eligible under Section 3 because he engaged in an insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. The district court conducted a 5-day trial and then found by clear and convincing evidence that Trump engaged in an insurrection as those terms are used in Section 3 of the 14th Amendment. However, the district court concluded Section 3 does not apply to the president because the presidency is not in office and therefore the president is not an officer of the United States. The plaintiffs appealed and the Colorado Supreme Court partially overturned the district court decision, finding that Trump committed insurrection and that he was an officer of the United States. The first issue was whether the state had jurisdiction to decide whether a presidential candidate had participated in an insurrection and was therefore disqualified from the ballot. Now, you might legitimately wonder why in the world we would want 50 different standards for how an election is administered. Well, take that up with the founding fathers. Since the Constitution delegates to the states the authority to prescribe the times, places, and manner of holding congressional elections, the states retain the power to regulate their own elections. Now, I'm not going to do a deep dive into the applicable Colorado statutes because we have a lot of material related to the federal Constitution, and the Supreme Court's not going to care that much about the actual Colorado election law issues here. So let's move on to the text of Section 3 of the 14th Amendment to the federal Constitution, which reads, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in an insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 of each house remove such disability." Section 3 was added to the Constitution after the Civil War, when Northern Republicans were outraged at the prospect of Southerners who seceded from the Union returning to hold positions of power in the same government that they tried to destroy. This was their way of saying that if you ever participated in an insurrection in this country, you aren't eligible to serve as an officer of the United States. But they didn't define all the terms that they used in Section 3, so the court had to do it for them. So the Colorado courts first had to determine whether Trump had participated in an insurrection. When the 14th Amendment was ratified, there was an assumption that everyone knew what an insurrection looked like because there had just been a civil war. It seems that Congress would block anyone that it felt had participated in the Confederacy. But in the absence of a civil war, what are we to do? Well, the Colorado Supreme Court started with the dictionary definition of the word insurrection. Merriam-Webster says it's an act or instance of revolting against civil or political authority or against an established government, or an act or instance of rising up physically. And the court agreed that insurrection, for purposes of Section 3, has to include a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transition of power in this country. And the Colorado courts concluded that whatever definition you're using, it would apply in this scenario. Right after January 6, Republicans quickly recognized that what had happened met the general definition of insurrection, just like their Reconstruction-era ancestors. Here's Majority Leader Mitch McConnell on January 7, 2021, using the same definition as the Colorado court.
It was a violent insurrection for the purpose of trying to prevent the peaceful transfer of power after a legitimately certified election from one administration to the next.
Trump's lawyers declined to offer a definition of insurrection, instead arguing that an insurrection is more than a riot, but less than a rebellion. The court agreed that, quote, an insurrection falls along a spectrum of related conduct, but no authority supports the position taken by President Trump's counsel at oral argument that insurrectionary conduct must involve a particular length of time or geographic location. The bottom line is that there has to be a group of people who use violence in a public way, and violence also has to be directed towards achieving some kind of public purpose. A private act or even a conspiracy to commit a crime doesn't rise to the level of insurrection, and the required force or threat of force doesn't require bloodshed, nor does it require those involved to be highly organized at the insurrection's inception. And you can see how this definition might include Trump's actions before and during January 6th.
Mike Pence is going to have to come through for us, and if he doesn't, that will be a sad day for our country.
Pence cave, we're going to drag through the streets. You politicians are going to get drugged through the streets.
And during the events of January 6th, the court said, quote, it is undisputed that a large group of people forcibly entered the Capitol and that this action was so formidable that law enforcement officials on site could not control it. The court slammed Team Trump for arguing that no one was armed on January 6th, since the mob was armed with a wide array of weapons.
The Oath Keepers stored a cache of weapons for a QRF, or quick reaction force, that would respond to the Capitol armed if President Trump were to, quote, declare an insurrection and to call us up as the militia.
Many of the rioters also stole objects from the building and even from the police, including metal rods, shields, and batons. And then the court considered whether Trump really engaged in an insurrection for purposes of Section 3, since Trump wasn't with the mob when they entered the Capitol building. There wasn't really much precedent, so the court looked at treason cases. In 1807, Chief Justice Marshall explained that, quote, all those who perform any part, however minute or however remote, from the scene of action and who actually leagued in the general conspiracy are to be considered traitors. The Colorado court held that engaged in requires an overt act and voluntary act done with the intent of aiding or furthering the common unlawful purpose, and concluded that Trump engaged in an insurrection. Here the court notes that Trump laid the groundwork as early as August of 2020 when he said the election would be rigged against him. In September, he refused to commit to a peaceful transfer of power. The court emphasized that Trump and his supporters were united in the purpose of stopping Congress from certifying the election. Quote, the mob was coordinated and demonstrated a unity of purpose. They marched through the Capitol building, chanting in a manner that made clear that they were seeking to inflict violence against members of Congress and Vice President Pence. And upon breaching the Capitol, the mob immediately pursued its intended target, the certification of the presidential election, and reached the House and Senate chambers within minutes of entering the building. The mob achieved its objective, at least temporarily. Quote, this breach caused both the House and Senate to adjourn, halting the electoral certification process. In addition, much of the mob's ire, which included threats of physical violence, was directed at Vice President Pence, who, in his role as president of the Senate, was constitutionally tasked with carrying out the electoral count. In other words, the mob wasn't on a tourist trip taking selfies, as some Republicans have recently insisted. They wanted to stop the peaceful transfer of power. Now, if you ever get kicked off a ballot, then you'll need a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've been in a car crash, suffered from sexual harassment, or are dealing with Social Security or workers' comp issues, we can represent you or help find you the right attorney who can. It's so important to talk to an attorney right away so you don't lose your chance for a full recovery and maximize your options. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is below. The Colorado Supreme Court agreed with the district court that Trump was no innocent bystander in these events. He recruited, quote, Proud Boys, the Oath Keepers, and the 3 Percenters, QAnon conspiracy theorists, and white nationalists to travel to Washington, D.C. on January 6th. The court concluded that Trump was aware of and sanctioned violence. The court suggested that the mob never would have assembled if Trump had not invited them. Quote, at this point, the record established that President Trump's plan was that when Congress met to certify the election results on January 6th, Vice President Pence could reject the true electors who voted for President Biden and certify a slate of fake electors supporting President Trump, or he could return the slates to the states for further proceedings. Now, the Colorado Supreme Court overturned the lower court's decision that the president is not an officer of the United States. Now, the district court concluded that the presidency is not an office, civil or military, under the United States for 2 reasons. First, the court noted that the presidency is not specifically mentioned in Section 3, though senators, representatives, and presidential electors are. The court found it unlikely that the presidency would be included in a catch-all of any office, civil or military. Second, the court found it compelling that an earlier draft of the section specifically included the presidency, suggesting that the drafters intended to omit the presidency in the version that it passed. But the state Supreme Court concluded that the specifics of that change don't prove that there wasn't an intent to exclude the presidency from the covered offices. This part of the majority opinion focuses on the spirit of the law rather than the letter, because it concludes that it would have been logically absurd for Section 3's drafter to exclude the president from the list of people who shouldn't be allowed to hold elective office if they participated in an insurrection. Quote, the drafters of Section 3 were motivated by a sense of betrayal, that is, by the existence of a broken oath, not by the type of officer who broke it. All of us understand the meaning of the 3rd section, Senator John Sherman stated. It includes those men who have once taken an oath of office to support the Constitution of the United States and have violated that oath in spirit by taking up arms against the government of the United States are to be deprived for a time at least of holding office. The majority opinion also makes a textual argument by finding that, quote, the Constitution refers to the presidency as an officer 25 times. The court also notes that the Constitution refers to the presidency as an office under the United States in several contexts that seem to support the conclusion that the presidency is such an office. And as another example, they cite the impeachment clause, which reads that Congress can impose, as a consequence of impeachment, a disqualification to hold and enjoy any office of honor, trust, or profit under the United States. If the presidency is not an office under the United States, then anyone impeached, including the president, could nonetheless go on to serve as president. This reading is nonsensical, as recent impeachments demonstrate. The court's point is that it would have been weird if the impeachment proceedings against Trump and Bill Clinton would have resulted in their removal from office and disqualification to hold any future office, except for the presidency. The Colorado court concluded that, quote, President Trump undertook all of these actions to aid and further a common unlawful purpose that he himself conceived and set in motion, prevent Congress from certifying the 2020 presidential election, and stop the peaceful transfer of power. The court held that Trump is barred from the primary ballot, although that decision stayed through the Supreme Court's review. Now, all 7 of the Colorado justices were Democrats, and the result was 4 votes to 3. The 3 dissenting justices also raised substantive issues that may get the attention of the Supreme Court. Some of the dissenting justices said that the court didn't give Trump enough due process. Now, what constitutes sufficient due process to disqualify someone from the ballot? That's an open question. Should the person have the same safeguards they would in a criminal trial? Or should the process be more like a civil case? We don't really know. Here, in this particular case, there was a 5-day trial in the district court where both sides presented testimony, and the court came to a conclusion. Trump was represented and filed briefs outlining his position. The parties called witnesses, and many third parties filed supplemental amicus briefs to help the court decide. But on the other hand, the hearing lacked discovery. Neither side could subpoena documents or compel witnesses, and it was decided by a judge rather than a jury. The dissenting justices also said that maybe there should be an independent procedure, something akin to a criminal trial, before a court rules that a person can't appear on the ballot. The disqualification clause is frustratingly silent on whether there must be an independent proceeding, so the question is whether Section 3 is really self-executing. Now, a law is self-executing if it is immediately effective without further action, legislation, or legal steps. The Supreme Court has never decided this issue, but Chief Justice Solomon Chase opined on it while he was a circuit justice for Virginia. In 1854, Chase was going to preside over the treason trial of Jefferson Davis. Now, that trial never happened because President Andrew Johnson gave him a pardon. But Chase allegedly told Davis's lawyer that he viewed Section 3 as a criminal punishment and that if Davis was disqualified, he would not face a criminal trial. Then in 1869, Chase decided a case called In re Griffin. Caesar Griffin had been sentenced to a 2-year prison sentence for assault by a state judge who happened to be a former Confederate officer. Griffin argued that the judge was disqualified under Section 3 and that it was self-executing. Justice Chase disagreed. Here he held that the legislation by Congress providing for removal was necessary to give effect to the prohibition of Section 3. And without such legislation, the judge was entitled to continue in his position. Now, remember when I said earlier about 50 states and 50 different rules? Well, the Michigan Supreme Court has ruled that Trump's candidacy was a political question, and Michigan law didn't give the Secretary of State the right to keep him off the ballot. But in Maine, the legislature delegated authority to determine candidate qualifications to the Secretary of State. So Maine voters filed 3 administrative challenges to Trump's presence on the primary ballot, and the Maine Secretary of State, Shenna Bellows, held a hearing where Trump's lawyers and the challengers argued the merits of disqualification. And Bellows has now ruled that Trump is ineligible to be listed on Maine's primary ballot. Now, the decision was made by the state official rather than a court, but the rationale is pretty similar to Colorado. Trump tried to prevent the peaceful transfer of power on January 6th. The riot was an insurrection, and Section 3 bars Trump from office. Bellows relied on the testimony of a historian who said that some, quote, members of Congress believed the presidency was in office when the amendment was being debated, as did contemporaries outside of Congress, including those who sought to keep Jefferson Davis from the presidency. Therefore, Bellows found it, quote, implausible that the drafters of Section 3 chose to exempt the highest office in our government from an amendment designed to keep Confederates from positions of power. Bellows said, quote, I am mindful that no Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. I am also mindful, however, that no presidential candidate has ever before engaged in insurrection. The Maine decision is pitched directly at the Supreme Court's conservative wing, which has ruled that the court must prioritize the normal and ordinary usage of words rather than secret or technical meanings that would not have been known to the ordinary citizens in the founding generation. And as Bellows notes, that language comes from the District of Columbia versus Heller, where the court held that the Second Amendment guarantees an individual right to possess firearms independent of service in state militia. Now, it's almost certain that Trump will appeal that decision. So the question is, will the Supreme Court take these cases on? Well, that's pretty likely. While the Supreme Court has just recently turned down Jack Smith's request for hearing the immunity cases directly without waiting for the Court of Appeals, it's hard to picture that the Supreme Court would allow states' courts to have the final word on the meaning of Section 3 of the 14th Amendment. And most commentators are assuming that the court will overturn the rulings and let Trump run for president in one way or another. But the way they do it, it's going to be, of course, very fascinating. But you can also be certain that the court will claim that politics had nothing to do with their reasoning. And you can already see how this case is scrambling the normal political and legal valences that would exist in a case like this, with many Democrats using principles of originalism or textualism to look at the text and original intent of the 14th Amendment to disqualify Trump from the ballot, and also many Republicans explicitly bringing politics into things, saying that we should ignore the textual and original meaning of the 14th Amendment and look to the political ramifications. And constitutional law professor Steve Vladeck has summarized the political and legal ironies that this case brings up on the excellent It's Complicated podcast.
I realize this is a weird argument for a constitutional law professor to make, but these are weird times. I mean, I tweeted this Tuesday night and knew I was going to get in trouble for it and did. But I think you can believe at the same time that President Trump engaged in insurrection and that he ought to be disqualified from ever holding office again, and also believe, given the Republican Party's casual relationship with truth and facts and evidence and widespread endorsement of January 6th related and election related conspiracy theories, that it's actually better for our politics if Trump loses having been on the ballot in all 50 states than if he loses having been kept off the ballot in a handful of states by this, maybe correct Asha, but novel application of a constitutional provision that very few people had heard about before 2021. And so, I think what this really is, and I mean, you know this as well as anyone, is, the dirty little secret is that law is not an absolute, right? Law is part of a mush that politics is also part of. And I think that the Supreme Court probably was hoping against hope that they didn't get dragged into this mess. And that maybe the Colorado Supreme Court, like the Minnesota Supreme Court, found a way to not keep Trump off the ballot. And to me, the real headline of what happened on Tuesday is now I think the Supreme Court has to step in against, not wanting to, and in a way in which there's almost no, obvious win, right, for the Supreme Court.
Yeah, it's weird times in the world, and politicians are getting doxxed and swatted left and right. all for their political beliefs, which is terrible. Never swat someone. It's a felony. You'll go to jail. But it's possible because so much of your personal data, like your personal address, is online, which is why I use today's sponsor, Incogni. Incogni removes your personal data from online data brokers. They reach out and make sure it's taken down. If these data brokers object, which I've seen, Incogni will take care of that too. It's amazing. Now, I don't know if you've ever Googled yourself, but there are major people search sites out there that probably have your personal contact info too. It might be because of a data hack, but sometimes our friends and family even provide that info voluntarily by clicking on one of those boxes when they sign up for websites or apps. These sites provide in-depth records, including information such as home addresses, contact details, license plate numbers, family members, financial information, and even religious and political beliefs. These sites can expose you to a wide range of dangers, from scams to identity theft to online harassment and stalking. Now, it was very important for me that I not appear on those sites, and Incogni took that information down. And not only does Incogni help with your online personal info being taken down, but it can also stop marketing efforts. I've seen a huge reduction in the amount of spam emails that I get, spam calls, and spam texts. And it's no surprise why I was getting all of this spam. According to the 2022 Annual Data Breach Report by the Identity Theft Resource Center, the number of victims has gone up nearly 41% from 2021. I was constantly getting notified that my information was part of a data breach. So when that happens, Incogni fights for you to have your personal data taken down from data brokers. Believe me, so many people have it, tackling this yourself would be nearly impossible. But that's where Incogni comes in. Incogni fights on your behalf to remove your personal data from data brokers and deals with any objections from their side. All you have to do is create an account and give them approval to work on your behalf. Incogni conducts repeated ongoing removals because even if the brokers remove your data once, they can collect it again and then use it again. Incogni makes sure that your personal information stays off the market for good. And it was fascinating for me to look at my own dashboard and realize that I'm on hundreds of data brokers lists. Here's part of my personal Incogni dashboard. It shows that these 3 sites had data on me that was rated 10 out of 10 on Incogni's sensitivity scale. These brokers had data including my contacts, financial data, and health data. It was terrifying to see exactly how many brokers had my data, but it was really fun to watch Incogni get them to delete that info one by one. So if online privacy is important to you, give Incogni a try. You can click on the link below to get 60% off Incogni when you use the code LegalEagle. So again, to get an exclusive 60% off discount, just click on the link that's on screen or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court. If someone asked you if you ever partied with Donald Trump in the presence of underage girls, you're gonna say no. But you are not Jeffrey Epstein, who was asked that exact same question and answered this.
Though I'd like to answer that question, at least today, I'm going to have to assert my 5th, 6th, and 14th Amendment rights, sir.
He'd like to answer that question. Well, I don't exactly know what that means, but I do know why people plead the 5th during depositions. So today we're going to unpack what it actually means to invoke the 5th, 6th, and 14th Amendments during a civil proceeding, why this clip is going viral, and what you can and cannot conclude from this very disturbing video. Now, I'm not going to belabor the point about who Jeffrey Epstein is. I'm sure you already know if you're watching this video. But here is a quick recap that we need to know to understand everything about this clip. Jeffrey Epstein was a wealthy financier and sex offender who had ties to several prominent politicians and celebrities. Epstein's estate was valued at over $550 million at the time of his death. And in 2007, Epstein faced federal charges for sexually abusing dozens of underage girls. But instead of prosecuting him in federal court, U.S. Attorney Alex Acosta approved a secret non-prosecution agreement that allowed Epstein to plead guilty in state court to 2 lesser charges: solicitation of prostitution and solicitation from a minor. Under this deal, Epstein served just 13 months in county jail, and federal prosecutors agreed not to charge him or any of his co-conspirators. And that sweetheart plea deal is the subject of Ghislaine Maxwell's current appeal to the Supreme Court. Now, this deal was kept secret from his victims, which arguably violated federal law, and one court said Epstein's victims, quote, suffered unspeakable horror at Epstein's hands, only to be left in the dark, and so it seems affirmatively misled by government lawyers. In 2017, President Donald Trump appointed Acosta as his Secretary of Labor. Acosta's role in the Epstein case went largely unnoticed until the FBI arrested Epstein for sex trafficking. The backlash forced Acosta to resign in 2019. And a few months later, Epstein died by suicide while he was in jail. Though by that point, Epstein's victims had sought justice for many years. In the 2010s, dozens of women sued Epstein for sexually abusing and trafficking them when they were minors. And the lawsuits alleged that Epstein lured them with promises of money, modeling opportunities, or help with education, only to coerce them into giving massages that quickly turned sexual. Some women said they were abused repeatedly over months or years, and that Epstein trafficked them to other powerful men. And accusers say Epstein continued to run his sex ring out of the U.S. Virgin Islands, where he owned property. The Attorney General for the U.S. Virgin Islands described it as, quote, the perfect hideaway and haven for trafficking young women and underage girls for sexual servitude, child abuse, and sexual assault. And separately, the U.S. Virgin Islands also filed a lawsuit seeking $190 million in penalties and disgorgement from JP Morgan Chase, alleging it benefited financially from Epstein's sex trafficking operation and failed to report suspicious financial activity. Now, the first publicly recorded lawsuits against Epstein were in 2008, when Jane Does sued him in Virginia and Florida. In 2010, Epstein settled a spate of lawsuits from victims who alleged he abused them in Florida when they were underage. And in 2014, more Jane Does came forward. They alleged Epstein ran a sex abuse ring and lent underage girls to, quote, prominent American politicians, powerful business executives, foreign presidents, a well-known prime minister, and other world leaders. And the lawsuit identified Prince Andrew and lawyer Alan Dershowitz as Epstein alleged clients. Then in 2019, 3 women sued Epstein in New York. 2 of the plaintiffs were young aspiring dancers. Epstein lured them to his orbit by promising to introduce them to prominent people in the dance industry, and they alleged that he assaulted them repeatedly during massages. Another woman said Epstein promised to pay for her medical care, only to coerce her into providing sexually explicit photographs of her while he was actually in the work release program. And after Epstein's death, more than 150 women sought settlements, according to records of payouts by his estate to the Jeffrey Epstein Victims Compensation Fund, which is set up in the Virgin Islands. The estate has paid out over $121 million to these victims between 2020 and 2021, and 92% of the claimants accepted offers from the estate, but as a condition of settlement, their names and allegations remain anonymous. So the actual number of victims in settlements is likely much higher. Many of Epstein's civil cases were settled quietly with non-disclosure agreements before his 2019 arrest, and one of the most high-profile cases was brought by Virginia Giuffre, who accused Epstein and his longtime associate, Ghislaine Maxwell, of recruiting her as a teenager and forcing her to have sex with Epstein and his powerful friends, including allegedly Britain's Prince Andrew. Now, in 2010, the prince famously flew to New York City to meet with Epstein shortly after Epstein got out of jail. And in 2021, Giuffre sued Andrew for battery and intentional infliction of emotional distress. Giuffre died in April of 2025, and her death was ruled a suicide. However, Giuffre's case, along with others, helped expose the scope of Epstein's abuse and was a driving force behind the release of sealed court documents, including flight logs and depositions. Now, a deposition is part of the discovery process where one party is allowed to depose one or more witnesses under oath. Basically, the attorney is questioning that witness and they're under oath as if they were testifying in court. And historically, those depositions have been recorded using a stenographer who takes contemporaneous notes. But in addition to that, in modern day, usually in a large enough case, you're going to videotape those depositions as well. But what's important here is that in the relevant depositions in the discovery proceedings of these cases, Epstein was deposed and invoked his Fifth Amendment rights thousands of times. And that brings us to the moment, a 2010 deposition where Epstein is under oath, being questioned about his connections to Donald Trump. So as you might have seen earlier this week, the channel Midas Touch resurfaced a clip from a 2010 deposition where Epstein is being grilled by a lawyer for one of his victims. Now, it's not clear which lawsuit this deposition resulted from, but the New York Times first reported on the video back in 2019. But as we talked about, around this time period, there were a ton of lawsuits against Epstein. So if you have discovery from any of these lawsuits, let me know. But this clip starts with a relatively benign question that Epstein does choose to answer.
Have you ever had a personal relationship with Donald Trump?
What do you mean by personal relationships?
Have you socialized with him?
Yes, sir.
Yes?
Yes, sir.
So at this point, Epstein does not invoke his Fifth Amendment rights, but then he's asked this question.
Have you ever socialized with Donald Trump in the presence of females under the age of 18?
Though I'd like to answer that question, at least today, I'm going to have to assert my 5th, 6th, and 14th Amendment rights, sir.
So what Epstein did there is known as pleading the Fifth Amendment. This is a legal maneuver that allows a person to refuse to answer questions in legal proceeding if the answers could potentially expose them to criminal or other prosecution. Now, rightly or wrongly, pleading the Fifth is frequently misunderstood by lay people to mean that a person is guilty of a crime.
The mob takes the Fifth. If you're innocent, why are you taking the Fifth Amendment?
Yes, that Donald Trump has often equated silence with guilt. He even tweeted during the Bill Cosby scandal, quote, "I'm no fan of Bill Cosby, but nevertheless, here's some free advice. If you are innocent, do not remain silent. You look guilty as hell." Of course, he changed his tune when he was being criminally prosecuted, and he personally took the Fifth hundreds and hundreds of times. But the right against self-incrimination isn't about optics. It's about constitutional protections. And in criminal proceedings, juries are not allowed to assume that silence equals guilt. So why did Epstein suddenly clam up when asked about Trump? Well, perhaps we can gain some insight by looking at why their friendship ended. In 2019, after Epstein's very public arrest, Trump claimed that he was not a fan of Epstein and ceased all contact with him about 15 years ago when a Florida real estate deal went sour. Trump repeated this story while distancing himself from Epstein's criminal behavior, all the while denying rumors that Epstein was banned from Mar-a-Lago for sexually harassing a teenage daughter of a club member. But a few days ago, Trump changed his story. Yes, Epstein was banned from Mar-a-Lago, but according to Trump, this was because he was trying to poach the staff.
Other people would come and complain, this guy is taking people from the spa. I didn't know that. And then when I heard about it, I told him, I said, listen, we don't want you taking our people, whether it was spa or not spa. I don't want him taking people.
And according to Trump, he definitely, positively never ever visited Epstein's island. It was, quote, one of my very good moments. I turned it down. I didn't want to go to his island. And one way to investigate whether these claims have any validity is to examine headlines across the political spectrum and examine the history of factual accuracy, as you'd often miss important details and facts if you only get your news from a few sources. And Trump's revised history with Epstein was covered by 211 outlets, with 23% of the coverage coming from the left, 62% coming from the center, and only 15% coming from the right. And from the left, sources were most likely to frame Trump's statements as quasi-admissions of guilt, focusing heavily on the phrase, I never had the privilege to visit the island. Center outlets provide factual, straightforward retelling without emotive or partisan language. And on the right, headlines typically frame Trump's statements as an explanation or revelation and go on to argue that they should be considered credible. Now, headlines and coverage vary greatly depending on the source, which is why I love today's sponsor, Ground News. The Nobel Peace Center called Ground News an excellent way to stay informed, avoid echo chambers, and expand your worldview. And I couldn't agree more. They've been a longtime supporter of this channel and independent journalism at large. So please consider checking them out. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the sources reporting, all backed by ratings from 3 independent news monitoring organizations. And I also love their blind spot feature, which shows you stories that are unreported by either side of the political spectrum. And with a topic like Jeffrey Epstein, there's plenty of blind spots to be discovered. And that's precisely where you'll find the story we just talked about, as it was unreported by both the left and right-leaning media. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. The subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. But even though the details about Trump and Epstein's relationship are muddy at best, it would be incorrect to assume that this is what motivated Epstein to plead the Fifth. To understand why, we need to break down the constitutional rights that he invoked and what they actually mean in the legal setting. But let's talk about the Fifth Amendment and why it's a cornerstone of our justice system. Now, the privilege against self-incrimination has its roots in 17th century England, where Puritans often refused to cooperate with religious interrogations. Many were pressured or tortured into confessing their faith, while others were presumed guilty simply for staying silent. Now, English law didn't formally recognize a right against self-incrimination until much later. But when the Puritans fled to America to escape religious persecution, they brought this principle with them. The Founding Fathers later enshrined it in the Fifth Amendment to the U.S. Constitution as part of the Bill of Rights. And over time, American courts have expanded this protection to cover situations where a person's words could be used against them in a criminal case. And the relevant text says, quote, no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. And you've definitely heard this right articulated in Miranda warnings on TV and in movies.
You have the right to remain silent. If you give up the right to remain silent, anything you say can and will be held against you in a court of law.
And that's because in a criminal case, the Fifth Amendment gives a defendant the right to remain silent and refuse to testify. No one can force a defendant to testify against their will. However, if a defendant chooses to testify, they typically waive their Fifth Amendment privilege for the remainder of that trial. That means they can't selectively answer some questions while refusing to answer others. And when someone pleads the Fifth in a criminal setting, prosecutors may not comment on a defendant's refusal to testify as evidence of guilt because it would unfairly punish someone for simply exercising their constitutional right under the First Amendment. And one of the core purposes of the Fifth Amendment is to protect innocent people who would be caught up in criminal proceedings through no fault of their own. That's why the privilege against self-incrimination extends not just to defendants, but to any witness in a criminal trial. And unlike defendants, witnesses can assert the Fifth Amendment selectively. They can choose to answer some questions and invoke the Fifth on others, depending on whether a particular question might incriminate them. And unlike criminal defendants, witnesses can be legally compelled to appear and testify. But the eagle-eyed among you might have noticed that this was not a criminal proceeding. This was a civil trial. Now, Fifth Amendment protections aren't limited to criminal trials, but they're also not the same in civil trials. In civil lawsuits like the one against Epstein, a witness can invoke the Fifth if their testimony would expose them to criminal liability in a future criminal proceeding. But this right is not absolute. In civil actions, the judge or jury can draw an adverse inference to support liability when the defendant invokes the Fifth Amendment. So in a civil setting, if someone takes the Fifth and refuses to answer, you can assume that the answer would be pretty bad for them. However, the adverse inference can only amplify other evidence. The Supreme Court has ruled that a person cannot lose a case if the only evidence is that person's silence. But invoking your Fifth Amendment rights in a civil deposition is not necessarily a signal that you're guilty. It could be a way to avoid giving answers that could be twisted or used later in a criminal trial, or that you just don't want to answer. And lawyers often advise clients to invoke the Fifth because even truthful answers can be risky when a parallel criminal investigation is in play. The Bill Cosby prosecution illustrates the complicated strategic dynamics between civil and criminal cases. In that case, more than 24 women accused Cosby of assault. And in 2005, Cosby gave a deposition in a civil sexual assault case brought by Andrea Constand. He answered the questions about drugging women and his sexual conduct only after a public assurance from the district attorney that he would not be criminally prosecuted. Cosby relied on that promise and waived his Fifth Amendment rights. So during his deposition, Cosby admitted drugging women with Quaaludes in order to have sex with them. Now that answer clearly incriminated him in criminal conduct. And over a decade later, a new prosecutor used that very testimony to charge and convict Cosby in a criminal trial. But in 2021, the Pennsylvania Supreme Court overturned that conviction, ruling that prosecutors violated Cosby's Fifth Amendment rights. The court had held that Cosby had relied on the government's non-prosecution promise when testifying, and using that testimony against him later was a clear violation of due process and the Constitution. Now, while the legal failures in the Cosby and Epstein cases were different, they both show how missteps in handling immunity and testimony can derail justice. Cosby's conviction was overturned because prosecutors violated an earlier promise not to criminally prosecute him, which induced him to waive his Fifth Amendment rights in a civil case. And in Epstein's case, the issue wasn't a Fifth Amendment violation, but rather a secret non-prosecution deal that protected him and his associates while denying victims their legal rights. But an additional complication is that all these rules only apply to the courts themselves. You, as a layperson viewing this testimony, can come to whatever conclusions you want to. As long as you're not a member of a jury, you can see someone invoke the Fifth and come to the conclusion that it's an admission of guilt. Especially in a context like this, where Epstein answered the question, does he know Donald Trump, but refused to answer the question, did he engage in any kind of incriminating activity with Donald Trump? But that being said, whatever conclusion you come to, you should understand that sometimes invoking the Fifth has nothing to do with being guilty or not. And there are a ton of reasons why you might take the Fifth that have nothing to do with being guilty of any crime at all. But additionally, Epstein also cited the 6th and 14th Amendments as well. And here's why. The 6th Amendment guarantees rights specifically related to criminal trials. These include the right to a speedy and public trial, the right to legal counsel, and the right to confront witnesses. While these protections are essential once a criminal case moves into the courtroom, they don't generally apply to a civil deposition, which is what Epstein was involved in here. Still, some lawyers have their clients invoke the 6th Amendment during depositions out of caution, especially if they believe criminal charges could follow. Especially where there are doe plaintiffs where they might not actually know the identity of the plaintiffs. And originally the amendments only limited the federal government, but the 14th Amendment, which was ratified after the Civil War, includes a due process clause that requires the states to honor most of the rights in the Bill of Rights, including the 5th Amendment and parts of the 6th Amendment. So when a defendant is in state court or in a proceeding involving state action, they often invoke the 5th Amendment and the 14th Amendment at the same time. So in Epstein's case, invoking the 5th and 14th Amendments made sense legally. Citing the 6th Amendment probably wasn't strictly necessary. It may have been just a way to signal that he believed the questioning could lead to unfair treatment or criminal exposure. In practice, though, the 5th Amendment was the one that was doing the heavy lifting. But there's one more interesting detail about pleading the 5th. Now, contrary to how it's often portrayed in movies or TV, the law does not allow a person to simply say, I plead the 5th one time and then remain silent for the rest of the proceeding. Instead, the privilege has to be asserted in response to each specific question that could potentially elicit incriminating information. This legal rule ensures that the court can evaluate whether the 5th Amendment truly applies to each individual inquiry. In fact, Epstein once pleaded the 5th over 1,200 times in a 2010 deposition. Epstein frustrated the plaintiff's lawyers by refusing to answer even the most basic questions like identifying a window in his mansion. When the lawyer asked him, quote, "And in this photograph, do you see a room depicted in the back?" Epstein replied, "5th." The lawyer asked him to clarify the quote, "You're taking the 5th about what is shown in this photograph." Epstein then said, quote, "I can't see anything, I'm sorry." The frustrated lawyer reiterated his question, quote, "Do you see a window depicted in this photograph?" And Epstein said, "I don't know what it is, I'm sorry." And as frustrating as this is for the lawyers, Epstein had a right to refuse to answer all the questions, though at the risk of imperiling the judgment in the civil case. But the high number is due to the legal rules requiring the witness to assert the 5th in response to each individual question, rather than issuing a blanket refusal. And by the way, we don't know if this deposition excerpt is the same 2010 deposition in which he was questioned about Trump. But I would not be surprised if the whole deposition eventually surfaces. And President Trump is no stranger to this tactic as well. In August of 2022, he appeared for a court-ordered deposition as part of New York Attorney General Letitia James's civil investigation into the Trump Organization. Trump invoked his 5th Amendment right against self-incrimination more than 440 times, answering only one question, his name. Though he did get that question right. And we know how that case turned out. After a months-long trial in 2024, Justice Arthur Engoron found Trump and his entities liable for fraud under New York law. He ordered them to disgorge over $364 million in ill-gotten gains plus interest, though the case is on appeal. But all this is a good reminder that if you have a legal issue, whether it's a criminal matter or a personal injury, you really need a great lawyer. And for more, here's my partner at the Eagle Team law firm. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle Team.
But the word tariff is the most beautiful word in the dictionary. Remember that.
Wow, so if we tariff the exports from other countries, they'll just pay us money with no downsides? Why didn't we try this before? Because that's not how tariffs work. And we have tried this before, and it might have caused the Great Depression. Just after the election, people suddenly started to search for how tariffs work and who pays for tariffs. The answer may surprise you, or it might be blindingly obvious. But can Trump install whatever tariffs he wants, and who pays for them? Chaos lawyer Liz Dye explains.
Thanks, Devin. Donald Trump has promised to slap 60% tariffs on all goods coming in from China and a 10% tariff on goods imported from all other countries. On the campaign trail, he even threatened to impose a whopping 100% tariff on auto imports from America's largest trading partner, Mexico. Before we talk about if he can legally do that or if it's a good idea, let's define our terms. The Center-Right Tax Foundation defines tariffs as taxes imposed by one country on goods imported from another country. Tariffs are effectively a tax on consumer goods paid by you and me and every other person who wants to buy stuff. So say that a Chinese manufacturer agrees to sell Nike a pair of shoes for $20. A 60% tariff means that the importer, that is Nike, pays $12 to the US government when those sneakers are offloaded from a cargo ship docked in Long Beach, California. Trump insists that the Chinese manufacturer is the one who ultimately pays for that tariff and that this will swell the U.S. government coffers with no impact on the American consumer whatsoever. But that's just wrong. The Chinese manufacturer is never going to eat the $12 tariff, and Nike doesn't want to reduce its net profit. So the end result is that the $12 tariff gets passed on to the American consumer at the point of sale, raising the wholesale price of that pair of sneakers by $12.
Yeah, if I can interject for a second, the problem is actually worse. You think, okay, a 60% tariff, so the consumer just ends up paying $12 more. Not great, but not terrible. But no, because sellers operate by gross margin. So if Nike imports a shoe for $20, they need to make a profit. But they aren't selling directly to the consumer. They need to sell the shoe to the retailer. And transport, advertising, and overhead is expensive. And doubling the manufacturing cost before selling it at wholesale would be totally normal. So let's say they sell it to Foot Locker for $40. But Foot Locker has to pay staff and operating costs in all their stores, which is expensive. So Foot Locker roughly doubles the wholesale cost of it again and ultimately sells the shoe to a consumer for $80. But that's in a tariffless world. A 60% tariff makes it $32 at import instead of $20, and $64 at wholesale, and then $128 at retail, assuming the same margins. So a $12 increase in tariffs on the cost of goods could easily result in a $48 increase in the final sales price that consumers pay. This is a simplification. In the real world, it would depend on the pricing power, and some of the costs would be shared between the parties, but you get the idea of how a small increase in cost of goods result in a much larger downstream cost to consumers. Plus, the domestic manufacturers don't just sit back while their foreign competitors raise their price. Why would they turn down free money when the consumer doesn't have any choice but to pay more? They raise their price to match or just undercut the foreign competition. Oh, and the cherry on top is that our foreign trading partners don't just sit back and take it either. They issue retaliatory tariffs against American exports, making them less competitive abroad. So people buy fewer American goods. And none of those taxes nor the original tariffs actually go to American companies. I don't know why people think this is boring.
In 1930, the Republican-controlled House of Representatives, in an effort to alleviate the effects of the, anyone? The Great Depression, raised tariffs. Did it work? Anyone?
If tariffs just make everything more expensive, why would we even want them? Well, in the early days of the Republic, we funded the government with tariffs on imports along with excise taxes on sinful products like alcohol and tobacco, which worked out more or less okay for about 100 years, especially for wealthy industrialists or the so-called robber barons who paid basically nothing to Uncle Sam. But in 1893, wheat prices crashed and an overexpansion of silver mines and railroads led to an economic bubble that burst. And even though the Great Depression hadn't happened yet, the Panic of 1893 ushered in the greatest depression that the country had ever seen, with unemployment rocketing to almost 20%. Imports dried up overnight, and no one had any money for alcohol and tobacco, which meant that the government had to go find some other source of funding. And that's how we wound up with a federal income tax instead of a pure consumption tax. In 1913, Congress ratified the 16th Amendment, which states the Congress shall have power to lay and collect taxes on incomes from whatever source derived. The U.S. government finally had a stable funding mechanism that wasn't directly tethered to the extreme ups and downs of the economy, and it was more fair. Because if you think about it, you only need one toothbrush, and Bill Gates only needs one toothbrush. But if the tax on a toothbrush is, say, 12 cents, well, that's a lot bigger share of your paycheck than it is of Bill Gates's. But Trump believes in cutting taxes on corporations and wealthy individuals, essentially returning us to the pre-16th Amendment days. In fact, the massive tax cut he rammed through during his first term is about to expire. Spoiler alert, it did not increase government revenues as promised, and now he wants to make those tax cuts permanent. So Trump has to find another source to make up for all the cash that will not be coming into the government coffers if he keeps cutting taxes for rich people. And that's yet another reason he's so invested in telling the lie that other countries pay import tariffs. In fact, it's a lie he's stretched to fit every occasion. Here he is in September explaining to the Economic Club of New York that the solution for skyrocketing childcare costs is, say it with us now, more tariffs. And you know what? We're going to let you listen to that entire 2-minute answer without any edits.
If you win in November, can you commit to prioritizing legislation to make childcare affordable? And if so, what specific piece of legislation will you advance?
Well, I would do that, and we're sitting down. You know, I was somebody, we had Senator Marco Rubio, and my daughter Ivanka was so impactful on that issue. It's a very important issue. But I think when you talk about the kind of numbers that I'm talking about, that, because look, childcare is childcare. There's something, you have to have it. In this country, you have to have it. But when you talk about those numbers compared to the kind of numbers that I'm talking about by taxing foreign nations at levels that they're not used to, but they'll get used to it very quickly. And it's not going to stop them from doing business with us, but they'll have a very substantial tax when they send product into our country. Those numbers are so much bigger than any numbers that we're talking about, including childcare, that it's going to take care. We're going to have, I look forward to having no deficits within a fairly short period of time, coupled with the reductions that I told you about on waste and fraud and all of the other things that are going on in our country. Because I have to stay with childcare. I want to stay with childcare, but those numbers are small relative to the kind of economic numbers that I'm talking about, including growth, but growth also headed up by what the plan is that I just told you about. We're going to be taking in trillions of dollars And as much as childcare is talked about as being expensive, it's relatively speaking not very expensive compared to the kind of numbers we'll be taking in. We're going to make this into an incredible country that can afford to take care of its people, and then we'll worry about the rest of the world. Let's help other people. But we're going to take care of our country first. This is about America first. It's about make America great again. We have to do it because right now we're a failing nation. So we'll take care of it. Thank you.
Now, sorry to interrupt, but if you're going to upend the entire economy, you'll probably want a good lawyer. But if you need a great lawyer, let my law firm, the Eagle team, help. If you've suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, were involved in a car crash, or have dealt with sexual harassment, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away to maximize your recovery and find out what to do next. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So click below.
Trump's tariff math is also rooted in the claim that making it expensive to import goods from overseas will immediately revive American manufacturing. That idea is formally known as trade protectionism. That is, protecting local industries by making it more difficult or expensive to import goods from foreign competitors. That was the rationale behind the infamous Smoot-Hawley Tariff Act of 1930, named for Republican Senators Reed Smoot and Willis Hawley, and signed into law by Republican President Herbert Hoover, despite a petition from more than 1,000 economists warning him that it would blow up the U.S. economy.
Anyone? Anyone? The Great Depression, the Hawley-Smoot Tariff Act.
The law imposed punishing tariffs of up to 59% on imported goods in an effort to protect American agriculture and industry. The tariffs are widely blamed for exacerbating the Great Depression, and they failed to curb unemployment, which continued to rise and remained high until the country entered World War II. They also wound up drastically decreasing the market for U.S. exports as other countries enacted retaliatory tariffs on American goods. Smoot and Hawley were both voted out of office in 1932, along with 10 other Republican senators, and Hoover lost to Franklin Roosevelt, winning just 6 states. And for roughly 75 years after that, conservatives opposed tariffs as a wasteful restraint on the free market, which is why the Tax Foundation says that tariffs are trade barriers that raise prices, reduce available quantities of goods and services for U.S. businesses and consumers, and create an economic burden on foreign exporters. Now, you may agree that propping up American manufacturing companies is a good idea. But you cannot escape from the simple math that tariffs are a tax levied on everyone in the form of higher prices for consumer goods for the purpose of ensuring that domestic industries won't have to compete head-to-head with foreign manufacturers, which is why Trump simply lies and says that it's a tax on foreign companies. Because if he said, under my plan, every non-food item at Target and Walmart is going to double in price, no one would vote for him. And okay, every country has tariffs. In fact, the U.S. has an incredibly complicated tariff system laid out in thousands of pages known as the Harmonized Tariff Schedule. How complicated? Well, here's an opinion letter from U.S. Customs and Border Protection to a costume company called Morph Suits, informing it that its Snake Eyes Ninja costume set should be classified as festive, carnival, or other entertainment articles, including magic tricks and practical joke articles, with 0 import duty. But the company's Captain Walker D. Plank set should be treated as other garments knitted or crocheted of man-made fibers, men or boys, with an import tariff of 14.9%. This distinction derives from a 2003 case called Ruby's Costume Company v. United States that differentiated between flimsy, non-durable garments that are essentially toys and well-made items that are functionally clothing. Like I said, complicated. But complicated isn't necessarily bad. Some problems just are complicated. And promising that you can simply wave a magic wand and fix those problems with one weird, simple economic trick is, it's a lie. Article 1, Section 8 of the Constitution says that Congress shall have the power to lay and collect taxes, duties, imposts, and excises, which certainly makes it sound like Congress has the power to impose tariffs. But over the years, Congress has delegated a lot of that power to the executive branch. Specifically, Section 232 of the Trade Expansion Act of 1962 grants the president authority to enact tariffs on essential imports relevant to national security. Section 232 was intended to give the president a tool to protect industries essential to fighting the Cold War. And Presidents Nixon, Ford, Carter, and Reagan all invoked that law to regulate oil production. But the Cold War is over, and no president has ever relied on 232 to justify a trade war, or at least not until 2018, when Donald Trump invoked it to justify a 25% tariff on imported steel and a 10% tariff on imported aluminum. Both of these raw materials are indeed essential to national security, but they're not in short supply in the U.S. economy. China and the EU lodged complaints with the WTO about Trump's tariffs, alleging that they violated international free trade agreements. Essentially, they argued that the U.S. was cheating by pulling a fire alarm and calling something an emergency as a tool to extract a better deal. Trump himself admits that he uses tariffs as a bargaining tactic. He couldn't even be bothered to stick with the excuse that he was protecting American security the last time. At various points, he admitted that his levies against China were in retaliation for Chinese theft of American intellectual property. And when Canada protested the tariffs on steel, he responded that they were punishment for Canada's 270% tariffs on American dairy exports. For the record, Canada does not impose a 270% tariff on American dairy products. Initial WTO panels agreed in 2020 and in 2022 that the U.S. had violated free trade rules with respect to China, the EU, Norway, and Turkey. But the U.S. blocked the appointment of judges to the WTO appellate panel, kneecapping the institution and preventing it from reaching a final resolution on any trade dispute. And by the by, President Biden continued to block those judges, meaning that the WTO will remain functionally toothless for another 4 years. But what does a Section 232 trade war look like for normal Americans? Well, the last time around, Trump's Commerce Secretary Wilbur Ross, a billionaire steel magnate, went on CNBC holding up a beer and a can of soup he claimed to have just picked up at the 7-Eleven to assure Americans that they'd never even noticed the tariffs.
In the can of Campbell's soup, there's about 2.6 cents, 2.6 pennies worth of steel. So if that goes up by 25%, that's about 0.6 of 1 cent on the price of a can of Campbell's soup. So who in the world is going to be too bothered by 0.6 of a cent?
Somehow, Republicans in Congress were not convinced by Wilbur Ross cosplaying as Joe Sixpack, and they begged Trump to call it off. Canada immediately announced that it would enact dollar-for-dollar reciprocal tariffs on American exports of whiskey, orange juice, and other food products. Prime Minister Justin Trudeau called the tariffs
an affront to the long-standing security partnership between Canada and the United States, and in particular, an affront to the thousands of Canadians who have fought and died alongside their American brothers in arms.
The European Union, which is also our stalwart ally, announced tariffs on $3 billion of American exports, including Harley-Davidson motorcycles. The import duty on Harleys headed for the EU rocketed from 6% to 31%, massively cutting into the company's profit margin as the Europeans opted to buy their bikes from someone other than the U.S. The Peterson Institute for International Economics said you could not find a better case study than this episode of how the Trump administration's trade policy weakens American export competitiveness. Harley-Davidson responded to the crisis by moving some of its operations to Thailand, where it could export to the EU without the 31% tariff, after which Trump encouraged Americans to outright boycott this American company. In addition to the Trade Expansion Act, Trump invoked the International Emergency Economic Powers Act of 1977, commonly known as IEEPA, to justify imposing even more tariffs. In May of 2019, Trump claimed that undocumented immigrants at the southern border constituted an emergency that justified escalating sanctions on Mexico to force it to intercept migrants from Central America and send them back to their countries of origin. Citing IEEPA, he said Mexico's passive cooperation in allowing this mass incursion constitutes an emergency and extraordinary threat to the national security and economy of the United States. And he promised a 5% tariff on all goods imported from Mexico starting June 10, 2019, escalating by 5% a month until it reached 25% in October, where it would stay until the, quote, illegal migration crisis is alleviated. That would have been a disaster for both the U.S. and Mexico, which is one of our biggest trading partners. Billions of dollars of goods move across the southern border every day in both directions. Plus, the timing of the announcement was especially awkward since the Trump administration had just finished hammering out the U.S.-Mexico-Canada agreement, which replaced the North American Free Trade Agreement. Trump pulled us out of NAFTA, insisting that he could get us a much better deal. Republicans in Congress, who had been painstakingly negotiating USMCA with our biggest trading partner, hit the roof. Trump's own staff eventually talked him out of the Mexico tariffs. Instead, they let him go out on June 7th and announced that he was magnanimously relenting after extracting unspecified accommodations from Mexico with respect to the border. In fact, he'd gotten nothing new. His advisors simply talked him out of doing something that would massively damage the U.S. economy going into an election year. In the first Trump administration, the president took his cues from economics advisor Peter Navarro. Navarro was very big on starting a trade war with China, which is hardly surprising since Trump's son-in-law, Jared Kushner, picked Navarro by trawling through Amazon's page on economics and cold calling the guy who wrote such works as The Coming War with China and Death by China. Navarro is obsessed with the trade deficit, which is usually defined as the amount by which a country's imports exceed the value of its exports. Now, experts are divided on what trade deficits mean for a country's long-term economic health. But the reality is that the U.S. is a rich country, and we have spent most of the last 5 decades negotiating trade deals that allow us to buy vast quantities of cheap consumer goods from poorer countries where production costs are lower. We all decided that we wanted $5 t-shirts from Bangladesh and $300 flat-screen TVs from China or South Korea, 2 countries which buy a lot less stuff from us than we buy from them. And that's fine. It's not like you're running a trade deficit with a haircuttery. You made the decision that you'd rather pay someone else to cut your hair rather than have your mom put a bowl on your head and snip around it. And as someone who's had a home haircut can confirm, that's not economic warfare. But Trump and Navarro believe that other countries are somehow pulling a fast one on us if we buy more sneakers and Halloween costumes from them than they buy cars, soybeans, and Marvel Cinematic Universe movies from us. And so they cooked up a plan to make those countries pay for the dastardly crime of selling us stuff we wanted to buy. Trump promised that trade wars are good and easy to win. When we're down $100 billion with a certain country and they get cute, don't trade anymore. We win big. It's easy. But it wasn't easy. Trump's steel tariffs in 2018 failed to bring back steel jobs. According to the St. Louis Fed, there were about 82,000 steel workers in the U.S. when Trump took office, and the exact same number when he left. But the steel tariffs caused the inputs for car plants and construction to go through the roof and precipitated the loss of a reported 75,000 jobs in steel-dependent industries. After Trump imposed tariffs on washing machines, producers raised the price of washers by an average of $86. But they also raised the price of dryers, which were not under any new tariffs, by $92. Because in a capitalist economy, if the government says, hey, Samsung, how about we give you a perfect excuse to raise prices, the company's not going to look a gift horse in the mouth. So while those tariffs brought in an estimated $82 million annually for the U.S. Treasury, they wound up costing American consumers an extra $1.5 billion a year to wash and dry our clothes. And the thing about starting a trade war is that other countries tend to fight back. So in 2019, American agricultural exports to China cratered as China slapped its own tariffs on American exports and shifted to buying wheat from Canada and soybeans from Brazil. The U.S. government wound up handing out $28 billion to farmers to cover their losses in this easy-to-win trade war. And the tariffs didn't even lower the U.S.-China trade deficit, which climbed from $375 billion in 2017 to $418 billion in 2018. All of which is to say that Trump can promise all he wants that he'll easily bring back U.S. jobs by piling tariffs on China, but his own track record says otherwise. It's hard to know whether Trump really does intend to impose across-the-board tariffs on day one of his presidency, because so often what he means is that he's going to threaten to do something totally crazy and destructive, effectively flipping the board in the middle of the game, in hopes that whoever's on the other side will blink rather than find out if this madman really does intend to go nuclear. If he does intend to impose massive tariffs, he'll have IEEPA, the Trade Expansion Act, and several other congressional delegations of legal authority to rely on. Those laws were intended for use in wartime or actual emergencies and not as a bargaining chip to threaten other countries into changing the terms of deals we've already negotiated. But the language in the statutes is vague enough to give Trump legal cover to do more or less whatever he wants when it comes to tariffs. The National Retail Federation is warning that if Trump really does levy massive tariffs on China, it will raise the price of consumer goods by between $46 and $78 billion a year. When asked about the tariffs in an earnings call in October, the CEO of Black & Decker, Donald Allen Jr., said that the company had been planning for this possibility since the spring, and coming out of the gate, there will be price increases associated with tariffs that we put into the market. AutoZone CEO Philip Daniele said in September, "We know what the tariffs will be. We generally raise prices ahead of that." Neither executive contemplates shifting production to the U.S., as Trump has promised his supporters would happen. As the Black & Decker CEO told shareholders, onshoring to America is not cost-effective, and there's questions about whether we even have the labor to actually do that in this country. Both CEOs agreed that they were much more likely to relocate from China to other countries in Asia or potentially to Mexico if Trump starts another trade war with China. All of which may very well hurt China, but it will do nothing to bring down costs for American consumers or create manufacturing jobs here or increase government revenue. And in fact, the Tax Policy Center calculates that if Trump really does impose a 10% across-the-board tariff and a 60% tariff on China, it would lower the average after-tax incomes of U.S. households in 2025 by about $1,800 a year. So yes, legally speaking, Trump can enact any tariff he wants to at any time for any reason against any country. All he has to do is shout, "It's an emergency." But whether he should is another matter entirely.
Well, I'm actually happy to report that Trump's business advisors advised him against the tariffs, and he's listening to them and is backing down. No, I'm just kidding. Trump recently announced on Twitter that he is doubling down on tariffs and stated that he's going to issue a blanket 25% tariff on all imports coming in from Canada and Mexico, as well as institute an additional 10% tariff on all goods coming in from China. For drugs, I guess. It doesn't really make all that much sense. So if Trump does what he says, I guess we're completely tearing up the USMCA and basically every other trade agreement that we have. Now that might be a terrible idea, but the one thing you should definitely do is subscribe to today's sponsor, Nebula, where you can learn even more about tariffs from my fellow creators. Like Morning Brew Daily talking about how the world economy is bracing for tariffs, TLDR News talking about how Trump would transform the US economy, and Money and Macro talking about how this will create another trade war. Because on Nebula, you can watch all of our videos ad-free and early, because our videos always go up on Nebula first. Plus, there's tons of exclusive content, and for a limited time, you can get a lifetime membership. You can buy once and then never again. It's the greatest steal of all. And I know tens of thousands of you signed up for Nebula using the Curiosity Stream bundle, but unfortunately, that's over. So if you want to support this channel, the only way to ensure that the money you spend on Nebula goes to us is to sign up directly. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. I've heard it described as Netflix for people who like trains, with your favorites like Johnny Harris, Neo, Jet Lag, Real Engineering, Real Life Lore, and obviously your most favorite, LegalEagle. And exclusives on Nebula are getting really good. Recently, I enjoyed watching RiffTrax's commentary over Plan 9 from Outer Space. It was the perfect video for Halloween. And how awesome is it that the RiffTrax and MST3K folks are on Nebula? And you can see my feature-length documentary, Bad Law Words Good, my other Nebula exclusive content, including my full-length interview with the screenwriter of My Cousin Vinny, and my Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is that it's a creator-owned platform built by me and other YouTubers and podcasters, and because it's a subscription service, we get to work on larger, higher-budget productions than we ever could anywhere else. It's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And this holiday season, for those of you that want to share everything Nebula has to offer with your friends and family, Nebula is now offering annual gift cards. So if you sign up using the link that's on screen right now or down below, you can give a year of Nebula to a friend for 40% off the yearly subscription. That's a year of the best content for just $36. And it's a gift that you can give to yourself, by the way, because you deserve it. So get 40% off of you or a friend's yearly subscription for just $36 a year. That's $3 a month for all of your favorite content, or you can check out the lifetime deal where for $300, you can get access to Nebula for forever. Because we're investing in more big concept, high octane Nebula originals, and your lifetime subscription goes towards that investment. In a way, lifetime is the best possible deal of all. But either way, you'll get LegalEagle videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on our own streaming site. So sign up now and get you or a friend 40% off of Nebula at $36 a year, or get the incredible lifetime deal by clicking on the link below. And after that, click on this box over here for more LegalEagle, or I'll see you in court.